In 1874, King Rama V devoted himself to developing and modernizing Siam in order to place it on the same footing with other civilized nations of the time. Not only did he intend to save the country from Western expansionism, but he also aimed to protect his subjects and uphold justice for all under his reign. This intention of King Rama V led to the establishment of the Council of State, which was modeled on similar bodies in European countries. The Council of State performed two major roles. One, assisting the king in the administration of state affairs and legislation. And two, deliberating grievances resulting from actions of the administrative sector. To establish the Council of State in accordance with his intention, King Rama V promulgated a royal proclamation, part of which states, "The Council of State is empowered to perform two basic functions. First, the Council is entitled to stop or block the king from ordering that which is unjust and causes hardship for his subjects, such as by making urgent calls for funds from his subjects throughout the land. Second, actions to be taken in the future must be reviewed carefully, and if it is seen that any are obstructive, incorrect, not to the benefit of the nation, not to the benefit of the monarch, or not to the benefit of the people in general, the Council has full authority to oppose such actions." It can be said that the first mechanism implemented to protect the rights of the people from unlawful administrative acts came into existence at that time. Although the Council of State was later dissolved, the effort to create a mechanism for justice for the people in times of dispute has continued without break. The establishment of the Council of State in 1933, the Petition Committee in 1949, and the merging of the Petition Committee with the Council of State in 1979 represent continued efforts to create an appropriate mechanism. Some efforts succeeded, while others failed, but they all laid the foundation for creating a strong and stable mechanism for the future. After a long wait, the light of hope shone brightly again when the Constitution of the Kingdom of Thailand, 1997, was enacted. This constitution allowed for the establishment of an entity which employed justices to adjudicate in administrative disputes between private individuals and administrative agencies, and which was separated from the courts of justice. This entity was named the Administrative Court. The effort continued, and 2 years later, the Act on Establishment of Administrative Court and Administrative Court Procedure, 1999, came into force on October 11, 1999. Shortly after, the Administrative Court was inaugurated on March 9, 2001. 127 years is a long time, but it has been worth the wait. In the end, Thailand finally established a mechanism for protecting the rights of the people when they were aggrieved by the actions of administrative agencies. Such a mechanism is modeled on judicial sovereignty for social justice in the name of the Administrative Court. In today's public administration, disputes between private individuals and administrative agencies or state officials may occur at any time and result from both intentional and unintentional actions. A dispute will end if a solution can be negotiated, but if the dispute cannot be resolved by the parties involved, an organization entrusted with the responsibility of making a judgment is necessary. The Administrative Court is the major institution in the nation which exercises judicial power in resolving administrative disputes. It aims to find a balance between the rights and liberties of the people and the work of the state for public benefit. In addition, it contributes to establishing good practices among administrative agencies and state officials. The law mandates that the administrative court has authority to try and adjudicate the following types of cases. 1. A dispute in relation to an unlawful act by an administrative agency or state official. For example, the unlawful issuance of a rule or order. 2. A dispute in relation to an administrative agency or a state official neglecting official duties required by the law or performing such duties with unreasonable delay. 3. A dispute in relation to a wrongful act or other liability of an administrative agency or a state official. 4. A dispute in relation to an administrative contract. And 5. A dispute prescribed by the law to be referred to the administrative court. The administrative courts are divided into two levels, namely the Supreme Administrative Court, which is a single court located in Bangkok, and the Administrative Courts of First Instance, which include the Central Administrative Court in Bangkok and regional administrative courts throughout the country. Expediting justice for the well-being of the people did not end with the establishment of the Supreme Administrative Court and the Central Administrative Court in Bangkok. The Administrative Court must continue to adapt to changing circumstances. Though the two levels of court structure have been established as prescribed by law, the Administrative Court has had to accelerate the establishment of regional administrative courts, as people in remote areas often have to travel long distances to the nearest administrative court. Presently, there exist the regional administrative courts in all regions of the country. The effort of the administrative court to provide justice to the public is reflected not only in the establishment and operation of regional administrative courts, but also in the procedure used to try cases. Adjudication by the administrative court is based on the inquisitorial system, which aims to provide justice to both the public and to the state, especially for those who are disadvantaged when filing cases against state agencies who have access to documentation that can be used as evidence and who have more expert and experienced personnel. The procedure employed by the administrative court to try cases relies on judges that are knowledgeable in public law and public administration and who are authorized to examine and search for relevant facts themselves, including requesting documents from both parties and making inquiries to clarify facts and make sure that all necessary information is obtained so as to ensure a fair judgment. In the adjudication of a case, the administrative court system requires a statement on the case, which includes opinions on case adjudication, must be made by a judge commissioner of justice, who is not a member of the adjudication quorum, in order to ensure that the quorum is as thorough and comprehensive as possible in its deliberations. This is because the law requires that in administrative procedure, the judgment and statement must be disseminated simultaneously. Some kinds of administrative cases may have the potential to impact strongly on the people or on the environment. Delay in the adjudication of such cases may result in severe and sometimes irreparable damage. The Administrative Court has therefore established specific divisions responsible for adjudication of those types of cases so that resentment can be reduced quickly and fairness ensured in trial. Both private individuals and administrative agencies can rely on the procedures used by the Administrative Court to provide tangible justice for all relevant parties. Any person, administrative agency, or state official aggrieved by an administrative act can submit a plaint in person or via registered post to the office of the Administrative Court located in his or her area of residence or district where the action occurred. Advice on administrative cases can be obtained from the Office of the Administrative Courts by calling the Administrative Court Hotline 1355 or by visiting worldwideweb.admincourt.go.th. Justice is our mission.